rely upon this beyond to the exclusion of every reasonable doubt, because there is a lack of evidence, there is a conflict in the evidence, and the evidence itself and the investigation itself stinks. I'd use another word, but I would probably get held in contempt. But I think you know what it is. So say we all.
Council, thank you. Ladies and gentlemen, we're going to take a short recess. The case is not being turned over to deliberations at this time. And remember, the admonition, you are not to discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence. Certainly no research. Just leave your notepads.
Still with me to help discuss closing arguments, family law and trial attorney Jenny Brown from Marietta, Georgia, and law enforcement and litigation expert Sonny Slaughter from Washington, D.C. All right, Jenny, let me start with you. I really liked one of the things he concluded with, ladies, and that was, if you waver and vacillate, that's what reasonable doubt is all about. What a great way to think about it.
I agree. He's saying if you have one iota of doubt, that is reasonable doubt and you should not convict. And he even said, if you think he's involved, that's not enough. And I think that's really important for this jury to understand is he might be involved and you might even think he's involved, but you have to confidently know he pre-planned this and he either shot them or was immediately with the person who did.
And I love the way you just summed it up, because it is true. If you think maybe he did it, that's very different than he did it beyond a reasonable doubt based on the evidence presented. Let me mention, Sonny, before I get your thoughts, that we are watching closing arguments from a little bit earlier. We now know the jury, and everyone can look at their clock on their screen. The jury's actually been deliberating for 12 minutes. So I just want everyone to be aware that the jury is out deliberating. But while that's going on, Sonny, a perfect time to, first of all, get your thoughts again now that he concluded his closing argument. And he did make a lot of arguments about life or death, life or death, life or death. That's what you are, this man is facing based on your decision. How compelling do you think he was?
I think it was really compelling, because sometimes when I think when we're looking at these trials and we're not a part of the jury, we don't understand. I mean, we're here and we understand how we're feeling, but I think the jury has to understand how important this case really is. I believe they've been paying attention. Hopefully they've been paying attention. But when you're deciding somebody's life in prison or death sentence, that is a heavy burden to carry, and they really need to be focused. I think he did a good job getting them zeroed in at the very end on whether not a little bit, but all the way in. So I think he did great. Yeah. We'll see.
He sure was passionate. I'll tell you, we talked about it. The thing that really stood out to me was when he reminded the jury the state had a sworn statement from a witness, and it really was conflicting to the state's case because it talked about Melly got into the car when he woke up. So it was really evidence that didn't help the state, I would argue. And Jenny, you and I both noted that, wow, the defense said we had to call that witness, not the state. I was taught in trial skills in law school, you cannot ignore a bad fact. You have to put it out there in front of the jury.
Right, and in fact, you want to attack those bad facts, right? You want to lay it out there and present it why it doesn't matter to your case and why this witness could not be trusted. But instead, now the defense gets to hone in on that and say, look, I told you they had blinders. I told you they weren't looking at anything else. So much so that they had somebody come in and give a sworn statement that they didn't even want to show you. We're not the ones lying to you. The state is. And that's where he's really trying to lay this foundation of mistrust.
And I think it's a huge misstep by the prosecution. Sonny, weigh in. Do you think this is something that jury might rely on to acquit this defendant?
Absolutely, because that one fact causes you to question, well, if they didn't bring this in, why not? What else didn't they do? What other information did they have that we don't know about? And if it was strong, as my co-guest said, bring it out so you can argue in it. Argue the case, argue the matter, But if letting the defense do it, that is enough reasonable doubt, in my opinion, to say they don't have a strong case.
Yeah, I think it was a misstep, but we'll see what the jury does. Jenny, do you think that the defense included any arguments that really might have resonated with each individual juror personally so that they could feel themselves being put in the situation, even though that's the golden rule? You can't say that. You can't say, imagine if this was your son who was killed. You can't do that. But did he speak to each juror individually, in your opinion?
Well, let's remember, he only has to speak to one, but I think he did. I think that he tried to lay that foundation of fear of what happens if you were in the wrong place at the wrong time and then something catastrophic happened and then they had blinders and they only focused on you. We're talking about a child. He kept going back to his age and how young he is and the gravity of the decision that they're having to make. So I think he probably did get to at least one of the jurors.
All right, Sonny, let me get your last thoughts about the defense's closing argument today.
I think the defense really tied the knot on the missing components and information from the prosecution, and that the state's case was not as strong as they thought it was. There were a lot of holes. It was not clear, concise, and consistent. And I think he went through every detail and provided, closed the gap, I would say, on everything that the state missed. So I think he did a good job. Let's see what happens, because this is a very serious case.
Yeah, I would agree. I think this is a case that really he might get acquitted. Now, I also think, though, my opinion is that the state did put out everything they had. I didn't feel like the state didn't do a good job giving the jury everything they knew and had. I just don't know that it was cohesive or was necessarily enough to convince all of the jurors to convict.
And what they had was complicated.
Yes, I agree with you. And if you don't lay it out in an easy way to digest, you're right, that can cause issues when it gets back to the jury. So just a reminder for all of you on your screen, we will have the jury verdict clock. 17 minutes is how long they've been deliberating in Florida, and we're going to keep that up and bring you any updates if there are any questions or a verdict in that case. When we come back, though, we are going to turn to Idaho. For a Chad Daybell update, Chanley Painter will be with us to give us all the latest. Stay tuned.
I started hearing these stories about murder and stuff.
I'm about to be the biggest drug dealer that you can become.
Oh my God, are they starting a war with me or what?
I'm not gonna lie, it felt good to be a gangster.